All right, everybody can see my screen, right? And again, just a reminder to everybody, if you want to see more faces than just the strip, you can go up to the top of your own screen and make it into a gallery view. And then you can see more people's faces if you want. So welcome everybody to the August Inc. Community Delegate Meeting 2023. We're going to have we've got a couple of great presentations tonight. I'm very excited. We're going to talk about good neighbor agreements in a little bit. And you know, we're trying to start on time, and we're going to try to end hopefully in a good amount of time tonight, and also you know, try to get some good information in, and hopefully we will be here. You know, we're scheduled to go till 8:15. We might go a little bit later. We'll see how it goes, but let's see here. I'm gonna move on to our schedule. Amber, were you gonna do the land and equity acknowledgement?
Sure.
Perfect. All right. Here you go.
Land and equity acknowledgement. As residents of Colorado, we stand on the unceded ancestral lands of the Arapaho, Cheyenne, Lakota, and Ute nations and peoples. These lands were also a site of trade, gathering, and healing for numerous other indigenous tribes. We recognize Native and Indigenous peoples as the original stewards of this land and our presence among their descendants who still dwell within it. We pay our respects to Indigenous and Native elders, past and present. Equity acknowledgement. We acknowledge that racial justice, equity, and climate justice are inextricably intertwined, and that poor, vulnerable, and primarily Black, Indigenous, and people of color disproportionately bear the burden due to the lingering effects of systematic discriminatory practices. We commit to doing our part to ensure that when taking any action to create a sustainable and regenerative future, we will respect, promote, and consider our respective obligations concerning all aspects of equity and strive to create systems in which everyone can thrive.
Great, thank you, Amber. I forgot to mention this at the beginning. Just a big welcome to everyone. And if you could put your neighborhood next to your name, that'd be great. And also, if you wanted to throw in the chat which neighborhood you're a part of, that would be great as well. And also a D by your name if you're a delegate. So we just—
Will you remind us how to do that?
So you have to click, you go down to your name, and there's a little down arrow or up arrow, I think, and you click on that, and it should say rename is one option, and that's where you can put in a D in your neighborhood. And then just throw your neighborhood in the chat too, and we'll just see who's from around where here in Denver. Oh, my name is Keith. I need to change mine actually as well. Great. All right. Well, I will get that done as soon as we start moving on here. So I think the first thing up is committee reports, and we can start off with transportation. Joel.
Good evening, everyone. Joel Noble. I chair the Transportation Committee for INC. Our meeting last month got preempted by the mayoral transition team's meeting. They had those 28 meetings for the different transition committees, and the one for DOTI, Department of Transportation Infrastructure, was the same night as our meeting. So a lot of our regulars went to that, and our next meeting will be September 14th, which is our regular time, 6 to 8 p.m. via Zoom. Got a great agenda. We'll be sending out the announcement soon. Also, with regard to the mayoral transition, I don't know if you've seen the announcement, but all the committees that worked on those transitions have produced reports. Those reports are up on vibrantdenver.com, and go under the media link, which is not terribly obvious, but you go under the media link and you can get a link to all of the transition committee reports, including, of course, the DOTI one, which I thought was very well done.
Great, thanks a lot, Joel. Up next, Jane, do you have a report for the climate and sustainability?
Yes, we have our bi-monthly meeting tomorrow night at 6:30. We've got some wonderful guest speakers, and I invite everyone to join us tomorrow night at 6:30.
Great, thanks, Jane. Yes, it's going to be on Denver's Urban Canopy, and I think we have two speakers from the city. One from I know is from the Urban Forestry Office. So it should be a really good meeting, and there's links online. I could throw one in the chat as well. Next is education. Joanna, are you there?
Good
Hey, hi,
evening,
Joanna.
everyone. Hi, good evening, everybody. So excited to announce my new co-chair who will be taking this over to give you guys an update. Steve Smith is the new co-chair for Education Committee. Steve?
I didn't admit him. I don't think he's here yet, Joanna. He might not be here. I don't see him as a participant either.
Yeah, Joanna, we can come back to.
Sure, yeah, come back. Thank
Okay.
you.
All right, thanks. And finally, I'm not sure if I saw Lamone or not, but Lamone, are you here? All right, well, we'll hold off on the DEI update as well. Maybe Lamone will join us in a little bit. Moving on the schedule, Jane, back to you. Do you want to talk about the upcoming award ceremony?
Thank you. Just an invitation to everyone who's a delegate and who represents the neighborhood. We'd love to have you attend on September 13th at Ricey's Brewery on West Colfax. This is the time that we honor individuals from neighborhoods who've done something out of the ordinary over the past couple of years. We didn't hold any awards last year, so we will be honoring people who've been nominated for things they've done the last couple of years. And I think we're going to have like 14 awards, a couple of group awards, some outstanding individuals for sure. I've been going over all of the nominations and submitting them to our committee who's reviewing them. The committee is Ann White and Pam Giner and Sally Kurtzman and myself. And so we're reviewing these applications and getting them ready for the opportunity to honor them that night with a Neighborhood Star Award or one of our special category awards. The invitation is online on the INC website. So I encourage you to sign up now with your Eventbrite invitation. And I think that Blair Taylor is trying to get on, and she wants to talk about the silent auction when she gets on. That's about all I have. I don't think there's anything new.
Great, thanks, Jane. I do just want to say that this is, I'm trying to pull this up here. This is the online invitation right here. And everyone, if you're a delegate, you should have received this, an email to this invitation online. And we're already taking RSVPs. We've got about 20 people signed up so far. Please take a minute if you can. If you think you're going to be able to make it, we would love to see you there. It's free for delegates from RNOs to just sign up. I'll probably be sending out an email in the next couple days just with a link to this as well to all the delegates, just to make sure that they have it, because we have about, I think 20% of the invites that haven't been opened yet. So we want to make sure that these get through any kind of spam filters or anything like that on your email. So if you haven't received this in the email, please contact us and let us know. So we make sure that we can get in touch with you because we definitely want to make sure you're getting the invites. Is Blair here yet, Jane?
I don't think so. She was having trouble connecting, but give her some time. Do
we want to go back to Lamone? Lamone, are you here? We did the committee reports. Do you want to do a quick DEI report? Do you have anything?
Lamone was here and then I noticed she went off. This is Jackie.
Okay, maybe she's got a bad connection. Okay. Well, I just also want to, let me make this into a slideshow again. I just want to, if you aren't, or your membership is on the cusp, we definitely would like folks to renew their membership to Inc. If you know, one of the parts of being a member is you get these 2 free invitations to our award ceremony in September. And if you haven't renewed yet, or it's time for your RNO to renew, please do that. Feel free to contact myself or Maggie Price at either of these emails about that if you have any questions going forward. And I think with that, we're about 18 minutes early here, and we're ready for our presentations to start. That's great. So I just want to start off with a huge thank you to Lou Raders and Gertie Grant and Amber Kraska for putting this together. I know they put a lot of time into this. And this is one of the things that I've been asked about personally several times over the last few months in finding out information more about Good Neighbor Agreements. So I'm really excited for us to be able to do this tonight. And I would also just like to say that we're going to have this information available after the presentation and up on our website in the future. So it'll be there. And our end goal here is to make a good resource guide for RNOs to be able to use. And I'm really excited that that's kind of the way that this has been structured. So with that, I'll just turn it over to Amber, and thanks again.
I just want to echo again Keith's gratitude to Lou and Gertie. I was fortunate enough to get to sit on a coffee chat with the 2 of them and be overwhelmed with just a mass of amazing information. I've only ever worked on one GNA myself. And going forward, we're going to use GNA referencing Good Neighbor Agreements. And then I just wanted to do a quick little short bio to let you know how well qualified these women are. Lou was a practicing attorney for 37 years with QTAC Rock, and she's now retired. And she's also president of Cherry Creek North Association. She spends her time now volunteering for a plethora of organizations, doing amazing stuff, not just for Cherry Creek North, but for the entire city. And she's worked on GNA and develop agreements for over 25 years. And then we have the amazing Gertie Grant with us as well presenting, and she was also an attorney. So you're going to have 2 high-level attorneys going over some amazing presentations with you tonight. She practiced law at the Denver District Attorney's Office in the Consumer Fraud Office for 12 years. She left law in 1988 and then started the Denver Digs Tree Program. And which is amazing, Gertie, that is still a program that many Denver residents look forward to every year. And she now volunteers her time on the Denver Tree Coalition. And she's been active in her RNO since 1977. And she's also been working on GNAs for over 25 years. So we are 50 years plus on amazing GNA information. So with that, Keith, if you could switch us to the next slide, that would be great. And this is just going to be real brief, just letting you guys know a good neighbor, when we're talking GNAs, that's a good neighbor agreement. And what this is a contract between the RNO and a developer or a business owner coming in and creating an agreement where the neighborhood gets to voice their concerns and the developer gets to hear those concerns, and then they come together to the table and go forward drafting what we're gonna reference as GNAs throughout the presentation. And then I just want to make one more point. There's probably going to be some questions that you guys are going to have. So rather than asking questions as we go, if you would put your question in the chat, I'm going to keep track of the questions. And then when Lou is going to go first, and then after Gertie's done presenting, I'm going to filter those questions, and then we'll get all of your questions answered at the end. Unless there's something right away that you need clarification for or something like that. But if it's a question, a larger question, if you could just put it in the chat, we'll go over it then. So with that, I'm going to turn it over to Lou.
Okay, everyone. Now I have started sharing my screen and I want to make sure that you can all see this.
Yes.
Yes.
Okay, great. I'm also going to suggest for those of you that would like to see this better, that you just reduce or maybe eliminate the thumbnail of the participants so we can focus on this, or at the very least, slide that little slider over so that the document itself has a little more room, because I am going to be going over this much like I did in the last presentation that we did last month when we talked about organizational structures for RNOs. So with that, I hope everyone can see this a little bit. I'm going to do this a little differently than Amber suggested. I'm not really talking just about GNAs. I am talking about the context in which RNOs can enter into agreements to address a lot of different concerns, including those that are much, much larger. And the reason that Gertie and I have both had over 25 years of experience with these is that there have been opportunities for RNOs to engage with developers and applicants for a long time. So what I'm going to do is I have a very detailed outline that, as Keith said, will be available through INC. But I'm going to go scroll through and I'm going to point some things out. I hope you can see my little cursor. And what I'm trying to point out is why it is that RNOs really should be looking at opportunities to enter into good neighbor agreements, development agreements, community benefit agreements, which is another term now being widely used for broader based agreements, so that they can take action to have a voice in their communities and the development in their communities. So let's talk about a couple of reasons that might cause a change in the zoning or other uses in your neighborhood and forms that might trigger an RNO wanting to think about a good neighbor agreement. So we have zoning changes, and we have wide zoning changes that was done that were completed in 2010. We have some additional changes since then. We've got administrative zoning changes. These are maybe a council person brings an administrative zoning change to a part of a neighborhood. We've got by far the most prolific filings will be individual property rezoning efforts, where a particular applicant, property owner, developer will file to rezone on a particular piece of property. We will have, for all of these, a few basic rules. All rezonings must be approved by City Council at the end of the process. The City Council member is notified of the rezoning by the applicant usually before they file, but once filed, that council member really isn't the person that the RNO goes to discuss the matter, because the City Council person has limitations on how much they can discuss for a matter that is pending before City Council. RNOs are able to file for support or objection to any of these processes. And again, you need to be a filed RNO, but once you are, you will have a process by which the RNO can and will have a voice. There are large site properties. They're usually called large development review process sites that are handled by CPD. The neighborhood will be brought into that conversation, but maybe not right away. But it's important for RNOs to watch for these, to know what is happening, and to make sure that the board of the RNO, through their development committee or zoning committee, is able to look at this and see how impactful it will be to all or a portion of the neighborhood for which that RNO acts. And so what can we do? What can neighborhoods do to address concerns or impacts of these proposed changes? So what is usually the case, and is to find that applicant, find out what they want to do, and see if they have an opportunity to sit down with that committee, with your board, with the RNO, with the whole community at community meetings to talk about what it is that they are trying to do in the neighborhood. They may be bringing new housing. They may be bringing new businesses. But if they are bringing anything that will have an impact that maybe the neighborhood is concerned about, that's the goal, is to end up talking to that developer applicant and enter into an enforceable agreement. Now, even if you don't end up with an enforceable agreement, there may be things that the developer is willing to do on their application, changing the looks of their building or something that would allow the neighborhood to take a formal position. I'm going to show you what this is the link that we will have for you on the Inc. website. And let me just bring this up for you. Can you all see that? This
Nope.
is the
I can't see the link. I can see that there is a link, but I can't see the link.
Oh, but can you see the document right now? Are you seeing what I am seeing?
I know what you're seeing, Lou.
It is, this is the actual form. I'm trying to show you the form.
Not on my screen.
We can't see it, Lou.
Others, but
Yeah,
That's
we don't
very
see it.
weird. If I'm sharing my screen, you should be seeing this.
You might just
Well,
be sharing one screen, and there's a way to put share all screens.
Okay, show grid. I don't know if that is an authorization. Why don't I just stick to, let me get rid of this. This is a document that is on the city's website, and it requires the application number, the location, all the information that the RNO is talking about. It's an important document for you all to look at and know is out there. So I'm sorry you can't see this right now, but do pull it up, because it requires meetings. You want to say when your meeting was held with your neighborhood, how many members were in attendance, and how the neighborhood voted on that particular application, and then provide comments. This is how the city learns what it is that the neighborhood is concerned about and what their position is, and that will go into the application file. Okay, so go back up here. All right, so one of the things that the RNO will look at when it analyzes these applications are the area plans. And you want to understand what the area plans are for the city. And I will do a quick pat on the back for INC, because INC was very instrumental in making sure that neighborhood plans came to fruition. I know that Joel worked on that and others, but this is the kind of thing that you want to look at your area plan and figure out whether the area plan is consistent or not with that application. This is a sample of Baker's. You can look at it when you get a chance. But what this makes clear is that neighborhood plans are more refined, more responsive to specific needs than the city's comprehensive plan. They serve as a supplement to the plan. They're neither official zoning, nor does it create or deny any rights. So, but it is what guides that zoning. Is the zoning being proposed in accordance with the area plan? If not, that would be something that the RNO would say, we don't support this because it really is not in accordance with our area plan or where we're going with our redevelopment of our neighborhood. And as we know right now, Denver is changing rapidly. So there are a lot of changes. So now I'm going to go into what these agreements are. So this is an introduction. I want to caveat again, I'm currently not licensed to practice law. Yay! I hung up my shingle when I retired. So I volunteer, but I have a lot of experience with this. And so what I'm giving you now is an outline of what these are and what R&Os can think about. We want Inc. to be a resource for neighborhoods so that they can get good work done in their neighborhoods. So what are these animals, these agreements? So what these are agreements where the applicant, developer, and the R&O will work together in a manner that will work for the neighborhood. What does this mean? It can mean anything from limiting the uses that would otherwise be allowable under the code, or it could be requiring more affordable housing. It could be requiring that the design standards of an adjacent design area apply to that particular property. These can be in all sizes. So the Park Hill Golf Course Benefits Agreement, now we all know it did not pass, whether you were for it or against it, the agreement is incredibly well done. Created by Otten Johnson and a host of others, including, I believe, Lamone, who worked on this committee, a host of others to really talk about what they would want to see. The details in that agreement are important for everyone to take a look at, because you can look at the kinds of things that are fair game to ask a developer to give. More affordable housing. How can they agree that there would be some space in this particular agreement as they provide for a grocery store? There were a number of very detailed neighborhood benefit provisions that I want R&Os to be aware of as we go through this, because it's not just a narrow range, which is why we don't have a particular one-size-fits-all form. So let's go through. There are many, many shorter agreements that I have worked on. Many of them, we are going to give you a copy of this. I'm not going to bring these up because the other form I was trying to bring up did not show. So I will just tell you that you will be able to find an example of a development agreement. This is one we did recently for a single office building on a corner in Cherry Creek North. The property is not in the business district, but we did want it to look like the business district because it was adjacent. So we had a lot of queries that the developer said, sure, we'd be able to do that, make it look consistent, add more bike parking, make that open to the neighborhood. We did not want as much traffic as a medical office building would require, because medical office buildings have a lot of people come to appointments. And they're 1 hour, 2 hour appointments. So they come and go and come and go. So we wanted to limit that particular use. So that's an agreement that you can take a look at and look at the things that the developer said, okay, we could do that. We can modify our development, and we put it in writing and we record it against property. Another example you'll find is for the Gateway development, which is up on First Avenue and Colorado Boulevard, very important corner. I also worked with Cherry Creek East on the Gateway development agreement that Colorado Boulevard and Bayard, both very, very critical corners for transitioning into the Cherry Creek statistical neighborhoods. And we had design elements. We even had, because they were so important, we didn't want residential units to have a lot of really messy balconies and views of windows if they were all glass, because these were gateway properties, important properties. So we asked the developer, and the developer agreed to make certain concessions on those points and to enforce them for us. So we recorded those agreements against those properties, and now we can rest assured as an R&O that as and when they actually come out of the ground, we can know what to expect and watch for it. Key components, and I'm going to go through this pretty quickly because this can get really boring because it really is basic contract law. So when you talk about agreement, contract, GNA, benefits agreements, they really are all agreements. Most of these are agreements in which the city is not a party. And so what we have to understand is that while the city acknowledges and we file these with the city, they are not going to be at the table negotiating these with you. They may help you. And there are some people at the city that have a lot of experience with these, but these are really private agreements that impact what happens at the city level. The exception to this will, Gertie will be talking about later, will be the kinds of true, quote, good neighbor agreements in the excise and license field where there's actually a license. So we seek to put certain restrictions on the face of the license. Then the license enforcement authority would enforce what's on the face of the license. So what do we need for a contract? We need contracting parties. That, again, it's private. The R&O is the one entity and the developer is the other. We want to make sure that that entity is an entity we know actually owns a property. Ask the developer for title reports. You can use this outline as a little checklist. How do I find out that that developer entity is a real formed entity and not just somebody they plan to develop in the future? So we want an entity that has contracting capacity, that is a legal entity. We also want, if it's a part of a project that is a single property, we want to know that that particular entity has the authority or owns that property. Then we go into recitals. Again, I'm not going to pull up an agreement that I was going to kind of show you how these things fall out because it didn't show on this. I'm just going to go through this outline. But you'll be able to see this when you take a look at this and you look at an actual agreement. There's something called recitals. So first it says this agreement's entered into to bind the parties, and then it says recitals. This is where you tell the story. Who is your R&O? Where is the property? And you can look at the examples to see what is the subject. This particular developer wants to develop a X-story office building on this particular property that you're going to define. You're going to set up your definitions and you're going to tell the story of what it is that you want to contract about. The other thing you need for a contract is you have to have consideration. That's a pretty simple thing. It says you have to give something such as a promise, act, or forbearance in exchange for getting something. So both parties have to end up with something, but it's the law is very forgiving on that. Most contracts have this language that I'm saying now, therefore, for $10 and other good and valuable consideration as the parties acknowledge and agree. That is actually sufficient. So keep your agreement simple for simple matters. Once you get through your reciters, you told your story, you know your parties, then you want to get to what it is you are trying to do. This is where the R&O specifically looks at what its concerns are. Do they not want a particular use, as I've mentioned? Do they want more than the required affordable housing? What it is that the R&O is looking to do, and then how do you draft it? This is where I'm going to have another caveat. There are times when an R&O and your board can look at a lot of samples and they may say, you know, I'm not really sure about this. When do you get a lawyer involved? This is where if you have lawyers or others in your neighborhood that can help you, great. If not, reach out, because there are very few areas where you absolutely cannot go, and that is to actually advise people in the practice of law. That's called the unauthorized practice of law. But if you're an R&O and you don't have the funds to hire counsel, then you can look at the starting points, get your agreement, look at what others have done, and see if you can at least get a good way there by yourself. The other thing I will say is there are times when it is fair for the R&O to ask the developer to pay up to a certain amount for the R&O to get its counsel. That's a fair ask, because the R&O and the developer are working together. The R&O gets to a point where it says, you know, I really would like to talk to a real estate lawyer about this. Developer, I want you to give me X thousand dollars to just go talk to somebody. And if it's a big project and the developer is really at the table in good faith, they may say that is absolutely fine. Let's try to do it succinctly and effectively and work together. Now, there are times when that doesn't happen. When you've got your agreement and it falls apart, you need to have in that agreement a way to enforce the document. So you want to make sure that, because you know the city's not going to enforce it, that you are able as the RNO to have a provision in your agreement that says that if the developer defaults and they don't do what they're saying, I mean, let's face it, the RNO isn't going to do much. At that point, they've already given their consideration, which is approval of the project pursuant to the conditions of the development agreement. So at this point, they've done what they need to do. The developer is just starting. And so there are a lot of things that could take the developer off task. All of a sudden, the project doesn't work financially. They come back and say, I can't do this. But if they just go out and start doing something that's not allowed, or if they sell the property to a third party, you need to know that there is a way that that you can enforce that agreement. I have a couple of examples here. These are examples of provisions that are provisions that give a notice of default to the developer. The developer has an opportunity to cure that. And if they don't, then the agreement can be enforced by a number of different methods. And what this also says, if the RNO actually has to file a lawsuit, they shall be entitled to recover all their reasonable court costs and attorney's fees incurred in connection with the proceeding. So that's another way to protect yourself on an attorney's fees, but it's you have to go back and get them instead of the negotiation example I gave you where you try to get that up front. So other examples that you'll see include a provision that says that the winning party gets to recover their fees. And there are several of them, so I'm giving you some example. There are a couple of other things that really matter to RNOs, and I'm going to finish up here pretty quickly here. When they welcome development in their neighborhood, as Cherry Creek North has, we upzoned quite a while ago. Our neighborhood plan contemplated rezoning from 1 to, in some cases, up to 12 stories. So we understand and have lived through a lot of construction. One of the things we do is we ask the contractors for the developer and have the developer oversee this. We ask for those developers. I'm going to slide down here to show you what this looks like. We ask for a good neighbor construction policy to be agreed to. What does this mean? It's pretty much courtesy, but you can limit construction times even more than the code does if that contractor and developer will make that happen. We can make sure that they put flyers, signs, letters explaining the project, when they're going to shut the water off. These you can look at your convenience, but these are guidelines and requirements. We want to have the phone number for the contractor, project site manager, so that if in the middle of the night there is something blows off the building and is teetering on falling on a neighbor's garage, they have a number that they can call, and that makes a big difference. So just a couple of other things here. Once you have your good neighbor agreement completed, you want to make sure it gets recorded. If it's not recorded against the property, then no third parties have official notice that it exists. If you do record it against the property and you say that it runs with the land, anybody who buys that property is going to buy subject to it. There are some a few exceptions that I won't get into in much detail, but you will see them in the examples I've given you. Is that we require that the construction lender or the land lender agree to and subordinate their liens, so the deed of trust liens, to this agreement, so that if they foreclose because the developer went belly up, they take the property subject to these terms of the agreement. But sometimes that doesn't happen. And then if there's a foreclosure and that lien was recorded prior to your development agreement, it'll get wiped out. A couple of other things just to point out is that once you record this, there might be things that change. Well-drafted agreements will contemplate that change. So if there's a code change, or if the city says, you know, I know they require that, but we don't allow that anymore under the building code, they're going to come back to you and ask for some changes. Make sure that you've got a savings provision, which if that is not enforceable, that the rest of the document will be. And also that there is a time when maybe it should not last forever and ever and ever. So we always say that, I'll highlight it here. You want to be able to amend it, but you also want it to be able to go away so long as they rezone. And then the neighborhood gets another bite at that apple. So if they want to get rid of this and they want to rezone the property, if you don't agree to it up front by just amending or terminating the agreement, they can file for a rezoning, right? And then you get another chance, because you're the official R&O, to look at that again and say, we don't approve that regardless. Or more likely what is going to happen is if things change so dramatically, nobody's working in office buildings. We certainly see office buildings constructed in Cherry Creek, but we have an office glut in our country. People talked about that happening for shopping centers. It hasn't happened to Cherry Creek, but other centers are experiencing them. If things happen where the economics change, you need to look at how you can work with that developer to modify what you've required to allow the property to thrive, the community to thrive, and frankly, the developer to continue to do what they do. The other thing I want to put a plug in here is to make sure that, as we talked about last time, if your R&O is an entity that is a Colorado nonprofit corporation, they're going to have built-in protections. And if your R&O is one that can afford D&O insurance, you're going to have that to protect you. But just in case you're not, I always ask that developers give us a hold harmless and indemnity, basically, understanding that while our board approved it, there may be people in the neighborhood who just don't believe that that's the right thing to do, and they may stand up and oppose it at city council. We want to put that out front and say that's not what we want to happen, but it can happen. And we want to make sure that we are protected as a board and as an R&O. And so you'll hold us harmless if anybody does that, or if there are any complaints about the agreement that you entered into with us. All right, I'm almost done. See, conclusion right here at the bottom. I do want to say something about equity because I think it's really important. We have equity issues in our city. We know that. We can't ignore the fact that some R&Os are not as, they don't have the processes in place that maybe larger, more experienced R&Os have. Language, resource differences make it harder for some R&Os to actually even get to the point where they say, how can we implement a development agreement to protect our neighborhood? So what we want to point out is that we've had these discussions. Lamone is the head of our DEI group, and we have been meeting on these issues. We understand, and our goal is to make tools available to all neighborhoods and eventually to help underserved neighborhoods, frankly, get the benefits of some of these tools. So that's what I will say about equity. It's important we keep it in the back of our minds as we do this work. So in conclusion, this is a primer, and yet it outlines some real basic information. And when I'm able to do this in getting these samples to you, I suggest that you look through these, look at the kinds of things we asked about, look at the standard format for some of these agreements, and look at the specific things that have been okay for some developers, and actually supported by some developers as they work with neighborhoods to become good neighbors and good employers and good owners in their neighborhoods. And that's it. Thank you very much.
Thank you so much, Lou. Man, what a plethora of knowledge you have. We got some good amount of questions lined up for you and Gertie after Gertie's done. So with that said, Keith, if you'll go back and share your screen, and Gertie's going to start on the next slide. And I'll hand it over to you, Gertie.
Okay, I want to thank Lou for working with me a lot on this, because she has a plethora of knowledge and she has worked at a much higher level than I have. My experience in the law was mainly in the district attorney's consumer fraud office. And the one thing that I learned that I can take away that's relevant to this is that somebody who is selling a product does not always disclose all the limitations on the product. And that's not applying to Lou and me, that's applying to, you'll see in a minute. Also, I want to thank Amber for helping me with this, because I am not a technological anything. And it's always quite difficult for me to do this. Okay, can you, I'm going to focus on good neighbor agreements, and I'm using them as a term of art within the context of liquor, marijuana, and cabaret license applications within RNOs. And it's important to do that because GNAs did not exist when Michael Henry and I first started negotiating with liquor license people who wanted liquor licenses years and years ago, before patios existed. And it has been a real change that's made it a lot easier for neighborhoods. Why do you want to negotiate or enter into an agreement with somebody who's applying for a new marijuana or liquor license in your neighborhood? There are two primary reasons, in my opinion. One is to establish good communication and a positive working relationship with the license owner and the neighbors. Both of you can benefit. Both sides can benefit. And I say sides because the liquor license application polarizes things. You either want it or you don't want it. They don't allow an in-between. You either support it or you oppose it. And so it is been complicated, and by the fact that there is no middle ground until good neighbor agreements were proposed by excise and license. Most of the neighbors want a good neighbor, want to have a new restaurant in the neighborhood, but they also recognize that some of the neighbors may want to enjoy the peaceful quiet of their homes, and they want to be able to sleep at night. And on the other hand, the applicant wants a successful investment. I think the hardest thing for us to recognize when we meet face to face with applicants is that this applicant is in here. They don't live, most of them don't live in the neighborhood. They are in here for a financial benefit. And so they are selling a product. And remember that when the applicant presents you with a marvelous menu or whatever of what they're going to do, the business plan is not part of the application. What they are buying or what they are selling to you is a business license. And those licenses can be sold. They are separate assets from the business premises where they're located. And some of them in my neighborhood near Broadway are over almost 100 years old, and they have been transferred over and over again. Before you meet with them, They have to have approval from the zoning department and also a lease in order to occupy the location. And the zoning code has some limitations, but for outside eating establishments in low-density residential zones. But other than that, there is very little protection from the zoning code. Now, where are we? We have moved on to why. Yeah, okay. Can you move on to the next? Oh, wait a minute. That's your fine. Stay right there, Keith. The Colorado law requires a legal public hearing for where the applicant has to prove to the licensing authority that the neighborhood needs and desires the kind of license. Those hearings in the past have been incredibly contentious. It's a battle of who can get the most signatures on petitions pro and who can get signatures on petitions against if the neighborhood doesn't want it. And they sometimes lasted, we've gotten evening hearings that have lasted until midnight down at Excise and License. And because of that contentious environment and the adversarial nature of the state licensing provisions, Excise and License came up with the concept of good neighbor agreements, and they were suggested and encouraged by Excise and Licenses. I don't know how long ago, but it was before patios were legal. It was a long time ago. So most of you listening to this were not even, well, you may have been in daycare when these were proposed, but Excise and License came up with this, and it was a way to get neighbors meeting with the license applicants and establish a way of resolving issues that both sides were concerned about, and also it can simplify correcting activities that are a problem and disturb neighbors if the terms get printed on the license. And that's the difference between, I think, there's a contrast, and I can't quite articulate it right now, between what Lou was talking about with getting it recorded with the city, or on the with the clerk and recorder's office, as opposed to a good neighbor agreement that gets admitted into evidence within a needs and desires hearing. But what did I need to say? Oh, I didn't include at the front of this the reference to the policies and procedures of the Department of Excise and License in their hearing procedures. Those are critical for people to read. They are understandable. They're written in normal English, and it's very important because they establish the rules by which hearings proceed, and they also tell you who can appear, who can testify, and what the process is for the whole license application hearing. Okay, can you move on to the next one? What are the good neighbor agreements? Okay, as Lou explained earlier, good neighbor agreements are a contract between an RNO and the license applicant. They do not involve the city in the execution or the enforcement of the license, with the exception of the terms in the agreement that get put on the license as a restriction. They have to include legal consideration. And for those of you who executed apartment agreements when you were out of college, the landlord gives you the right to occupy the apartment, and you pay the landlord rent. And that exchange of benefit is significant to the construction of a legally enforceable contract. It always bothered me when Robin Kinich and Andrew Webb of CPD referred to good neighbor agreements when there was no, in my opinion, legal consideration in some of the rezonings that they were proposing. Because if the object that is under consideration in the contract or so-called contract is a use by right, there is no legal consideration. But in a good neighbor agreement with a liquor license applicant, the legal consideration is the applicant wants the RNO to either support or not object to the license, and the neighbors, the RNO, get concessions from the applicant on things that otherwise they would be legally allowed to do. And the GNA must be, that RNOs can enter into a GNA with a licensed applicant, not just a group of neighbors, but it's important to remember individual neighbors who live in the designated area, and I'll explain that further down, can appear at the hearing and testify. The applicant's representative, and you need to make sure that when you're talking with them, that it is somebody who has the decision-making authority, that it's not just somebody's brother who or sister who is talking to you and says, yeah, that sounds like a good idea, we'll agree to that. But if they don't have the legal authority to represent the applicant, then you may be in trouble. Let's see. The real advantage of a GNA, and I'm using this in the context of new liquor licenses, cabaret licenses, and marijuana dispensary and sales licenses, is getting on the license terms that the city will enforce. And this is where GNAs in the context of liquor license, et cetera, hearings are different. I'm sorry, I got distracted by a chat question. Let's see, can you move on, please? To the next one. What is allowed to be listed on the face of the license can be different than what's agreed in the GNA. And that's partly because the city attorney and the Department of Excise and License reviews the information and then decides whether or not they're going to include it. There are some terms that we have had in our GNAs that we wanted on the license, but the city has determined they're not enforceable by the city, so it's not on the license. Let's see. But please remember, the entire good neighbor agreement is not automatically enforceable against somebody who purchases the license unless there is a legal assignment that is executed or a new GNA is negotiated. Can you go on to the next slide, please, Keith? When you get the notice from Department of Excise and License, you need to act quickly, and that's because the hearing policy and procedures requirements are that documents to be entered into evidence must be filed 7 days before the hearing. And that can give you a really short timeline. Sometimes it's as short as 3 to 4 weeks before the hearing. So you've got to move quickly. Now there are relevant documents that you get from the city when there's one coming in your neighborhood. Keith, can you move on, please? This is a liquor license application, and you can see in here the names that you will need to put in the good neighbor agreement. In this one particularly, there is a telephone number where you can reach them. Sometimes there is no telephone number, there's no email, and you have to go to Google and Google them and see how you can track them down. Keith, can you move on to the next slide? This lists the names of one of the owners. She owns 50%, And the other owner is listed, I think there was another page missing in this, I think. But Benjamin, now, don't, you're losing me. She's got 50 and her husband had 50, but go on to the next one, Keith. That's the application. This is the floor plan, an example of floor plan that shows where on the licensed premises, where are they planning on serving alcohol in this particular application? Keep going, Keith, please. As you can see, this is complicated. It's basically a 4-story building on South Broadway that is just opened, and it's really quite marvelous. Keep going, Keith. Here is more. Keep going, Keith. And this is the area of interest. This is the neighborhood under consideration, the designated area. The RNO's boundaries must intersect this area at some point, and any witness that testifies either in support or in opposition to the application has to live or operate a business within this area. Keith, can you keep going, please? And this notice from the city in here, tiny little print, is how you click on to join the hearing. The information up here has the hearing date, right here, the hearing date and time. And this document explains a lot of what you will need to do or what you need to know about the license and what the license applicant needs to do. Keep going, please, Keith. Next slide. Keep going. Okay, have a meeting if you can with the applicant. And the reason that's important is you can establish a face-to-face relationship with them, and you can also let them tell you what they're going to do, but you also can tell them what is unique about your neighborhood and why the terms that you think are important to have on a good neighbor agreement are there. But make sure that you know what are the features that might create late night or loud noises to neighbors living around this proposed establishment. The rooftop, serving areas on the rooftop, balconies, patios, etc. Large exterior wall openings and operable windows, containers for trash and recycling, and how near are they to residential uses now or in the future. Make this a friendly meeting to welcome the new business, and they sometimes can be adversarial, but most of the ones that I've been involved with have been very friendly, and it's worked out really well. But remember, the applicant is selling the virtues of the proposed establishment, and neighbors will probably be patrons of the business, but neighbors also are the ones who expect to be able to go to sleep at night. Let's see, bring a sample GNA with basic terms already approved by your board, and that neighbors, and it explains to the applicant what neighbors expect to come with the new development. Go ahead, please, Keith. This is a checklist that I've prepared because I think it's really important to make sure that you go through these things. I often come away from the meetings and I haven't checked them all. The thing that is, beside what I've already mentioned, is the timeline to draft and sign and file the documents, because a lot of times people aren't aware that you have to file them 7 days before the hearing. And also exchange phone and email information on both sides. Go ahead, please, Keith. Here's what you need to remember, and I've mentioned this before. The RNO must file the GNA 7 days before the hearing. And although there's some latitude, it's there. And if you abuse it with the hearing officer more than once or twice, they may exclude the documents you're trying to get in. And the documents you need to get in are the GNA and the letter that authorized the RNO representative to appear at the hearing. If the person who's appearing is the president of the RNO, that's not an issue. But if it's just a member of the zoning committee, you may need a letter or some authority, evidence of authority to represent the RNO. The RNO representatives at the hearing must live within the RNO's boundaries, but not necessarily in the designated area right around the licensed authority, a licensed address. And the RNO rep needs to be prepared to explain how the Good Neighbor Agreement was negotiated and the outreach to the neighborhood. You need to get the GNA into evidence and note that the parties agreed to terms to be on the license. And you need to request that the recommended decision be sent to the RNO, because that is not necessarily, it is not automatic and is not listed in the hearing policies and procedures. When you get the recommended decision, review it to see if the terms that you wanted to be on the license are there, and if they were modified by the hearing officer. And the same thing is, you may have to contact the Department of Excise and License technician to send the final decision to the RNO. Again, this is a learning experience to see what actually appeared on the license. Go ahead, Keith, please. Okay, this is a sample GNA, and I'm not going to go through it unless somebody wants me to. It's an example of a Good Neighbor Agreement. I changed the address because I changed some of the terms. But in yellow, it is the things that are particular to the establishment of the particular GNA. And the red explains what, in my mothballed attorney experience, is the reason to have that information there. I'm not going to go into that because I think we're running short on time, and I would like to open this up to questions.
Thank you so much, Gertie, and Lou, both of you guys. I mean, this is a lot of information. And yes, Amanda, I will answer your question. We will get all of these slides out to you, which will have links. Lou's had a bunch of links to other documents as well. You will be getting all of that information. And then I am going to start having Lou and Gertie answer some questions for us. I'm going to start with Guy's question. How many RNOs have the financial resources to enforce a GNA if the counterparty violates any agreed upon terms? Lou, do you want to take that one?
Yeah, so the specific enforcement is going to be dependent upon what is in the agreement. Like I said, if you have a provision in the agreement that says that if the RNO is forced to go to enforcement proceedings, which, by the way, have never seen have to happen if on a well-drafted development agreement, but it will say that the defaulting party developer has to pay the attorney's fees and costs for the RNO. That's going to make it much easier for the RNO to go to an attorney and say, will you help us file this? Because we expect to get these funds. I'm not saying that you're going to get a lot of people to volunteer to do this pro bono, but you should be able to find some resources in and within your RNO. But again, if it is a well-drafted provision, you should have some comfort knowing that those costs will be reimbursed.
Okay, great. And this is segueing into that, Lou. What is a fair amount? And I'm sure that it's also dependent on the size of the development, right? If you're doing a 10-story condo building, it's going to be a different amount than what it's going to be if it's a duplex in the neighborhood. So in your experience, you know, what is a fair amount? Or is there a basis?
Well, a couple quick points I'm going to make. First of all, I don't really think, I think good neighbor agreements, and we've done hundreds of them because we have so many restaurants and open patios with music in Cherry Creek North, and now a lot of condominiums in Cherry Creek North, that I have not really seen that there is a lot of lawyer involvement in that aspect of G&As. A lot of, and Gertie has provided a good example. But if we're talking about a big development agreement where you've got a 10-story building, or, you know, we're looking at a 13-acre parcel for Cherry Creek West over here at the mall. So, I mean, there are different sizes, and it could vary a lot. But if you're talking about a single parcel where somebody is trying to get something done, and the RNO has done a good job of going through some of these samples and listing, here are the parties, here's the property, here's what we want to do, and taking a shot at it, my guess is a reasonable amount to ask the developer is, say, could you go up to $5,000 for us to have a decent law firm negotiate the final terms of this on our behalf. Often what I do, because I'm no longer practicing, is I put the onus on the developer's lawyer to do all the work on their system, to have their secretaries run the red lines, send things out, put the big work on the developer, and then we're able to fill in by just doing the work and reading. And I see Gertie has her hand up too.
Yeah, go ahead, Gertie.
Yeah, I guess I've not done any of the agreements with developers when it's been a redevelopment of property. My experience has been totally with good neighbor agreements. In the liquor license, marijuana license context. And from my perspective, the most important thing that a neighborhood needs to decide is what terms are really significant to you that you want to get on the license, because the advantage of having it on the license is that you no longer, as an RNO, have to enforce it. The city enforces it. And if it says the patio has to close by 10 o'clock, then the city will enforce that. The licensing authority will enforce that. You don't have to enforce that. Now, some of that depends on who is the director of excise and licenses. And let's put it this way, there have been less enthusiastic enforcement of some of the provisions under different licensing authorities. But for me, the most important thing is deciding what an RNO says, what is their bottom line? And for me, the bottom line is noise. And if it's noise that leaves the premises in excess of that allowed by city ordinance, that is the bottom line. You can negotiate over patio hours. You can negotiate over trash pickup. You can negotiate over where their lights in their parking lot shine. But the most important thing is the noise that comes off the premises.
Great.
I
Okay,
will note on that there are some things that the hearing officers will not allow to be put on licenses. So, and the enforcement authority for noise is CDPHE. It is not excise and license. So you've got cross enforcement on those kinds of things, and I know that from experience. So just saying there, get what you can. I agree with Gertie, you get the most important things, but understand that noise, if you say it has to stay within a certain decibel level, and usually what you really want to do is make sure that decibel level is measured at your site. That's CDPHE.
Yeah, and Lou, you're absolutely right. Environmental health, getting environmental health out there can sometimes be very difficult, but we had an experience where once we got environmental health out there, we didn't have to go through the administrative process to show that they had violated the limits allowed under the ordinance. Once the guy got out there with his little meter and said, okay, business, your noise is exceeding that level, right then and there, they knew they had to lower it. And it was much better than having to go through the whole administrative process and then taking that back to the Department of Excise and License. That may be getting more into the weeds than we need to do, but anyway.
Okay, with that, I'm going to address Keith's question. We have developers that come to our R&O meetings every month asking for zoning changes to properties that they're interested in developing. Is that the appropriate time to ask them if they're willing to do a GNA or another type of agreement? If not, when in the development process is the right time?
The right time is really the first time that you can get your access to that developer. So as I'm also chair of the steering committee, so often they'll reach out to me in that capacity. But a good, well-positioned R&O, the developer is going to reach out. These are mostly for like rezonings and not necessarily complete use by rights, but they'll reach out to the council person and to the R&O head, or if you've got an overlapping steering committee in our example, maybe Chun would be another in their example, but that is the right time to say, we have some concerns about this. We'd love to talk to you about it. And then, you know, you take it back to your committee, you find out more about what they're doing, you listen to what those concerns are. We have had some issues with rooftop venues. We've not addressed those in the development agreement. We wait until they apply for a liquor license and we address it there. So some of it is knowing where to make your ask, but sooner the better, Keith.
Awesome. Okay, and then Lou, one of my question was, which party records the GNA?
Well, and let me just be very clear about, because I saw a couple of other questions. The process for, and I'm talking about development agreements that affect large developments, properties, rezonings, those kinds of things, and not necessarily, you know, you don't record a license GNA. I'm talking about the larger process development agreements. Those get recorded in the county in which the property is located. Clerk and recorder of Denver, since we're all in Denver, you record it there, but I usually will ask the developers council to get it recorded, and I like it to be done before planning board. And then there's a condition in the development agreement itself that says the enforceability of this and the effectiveness of this document is contingent on those entitlements being approved. So, but that way it's recorded. That way, if it gets flipped, or if a lender comes in, you're before the construction lender in priority on title. So that's when I ask for it to be recorded. And again, it is usually the case that when you're working amicably with the other side, that you can ask their lawyers to record it and send you a recorded copy. And Amber, if you want to just quickly close that screen, I'm going to just take this for a second and pull up that other, Keith, can you close the document, your document, for a second? Okay, I'm just going to share this R&O statement. Let's see, or did I already? Okay, I'm sorry. When I was trying to pull it up, I think I closed it. Let me just pull it up here again. All right, let me just go up here and I'm going to pull up this document that I was trying to show you, because this is really, if the, Keith, one of the questions, you know, when do you start that negotiation? If those are going south at that point and the entity that is working with you is not really willing to work amicably, there is no time like the present to then file this. Oh, it's not opening off of this. Well, I'm still not able to get it to share with you. I might quickly try to do that, and I'll bring it back up as Amber moves on with the questioning.
Well,
But But that's the time you want to file that with CPD. And there's difference between recording and filing. So when you're working with a rezoning, CPD is going to be working with that developer. There will be a case number and a case manager. They will communicate with you. You send your communications to them. And I'm going to stop sharing this so I can try to pull this other one up. And I'll show you what this looks like. So if they're not working with you and you say that we know that there's been a filed application on this, and we want to come out right now that that there is an opposition by our R&O, then you file that then. Does that make sense? With CPD, right?
Yeah, so I guess what, we typically get developers coming in at the, kind of the initial zoning, like usually it's upzoning for, an already potentially developed area into, an upzone. And if there was any, I didn't know if there was any stipulations that we wanted with that. Is the right time during the zoning application process, or is it during the process where they're showing us site, like coming back to our R&O with like site plans?
It's really, there are certain times that you have to have it by, but it's not too early. Can everybody see this form now?
Yeah.
Yeah.
Okay, this is what's online. That link will take you to it. This is the official position statement form by the city. So they're talking about rezonings here. So you plug that. So Keith, you would say these people applied, it hasn't gone very far, but you think, oh, this is so not consistent with our area plan. And they're going to see way more than we want to do. And they all of a sudden they've gone dark, which has happened to us. You want to get this on file with CPD, because you want to make sure that they know that you don't like what's going on here. And the earlier that the staff knows that, the better. And again, this comment section, you want, and again, tell your story. If you haven't had a meeting, but you've contacted all the immediate neighbors or your board, and you say, we are going to bring this to the whole neighborhood, but the board has vehemently opposed this, tell them that, because it's important for you to communicate with staff. I'm going to close this.
All right.
Thanks, Lou. Gertie, I got a question for you. Have you ever seen a GNA? When me and you and Lou met, we kind of talked about this a little bit. Have you ever seen a GNA discussing keeping trees as a part of the project?
No, I haven't. I wish I had. I think part of that would be if somebody is asking for a rezoning, and and Lou can answer this because I've never been involved in any kind of development agreements with rezoning, but it could be, I think, Lou, am I right? It could be part of the neighborhood's agreement with the developer.
Yeah, that would be an appropriate thing that would go into a development agreement. But it would also be, let's just take for instance. So you have a restaurant, it's going to be outside. They're going to have a patio serving outside, I would say. And you want that developer or applicant, even of the liquor license, to plant screening shrubs so that will help hide the light or something. You could ask for that there. You also have to be sensitive to anytime you start asking for specifics on trees. We often ask for the trees to be maintained, but the city will usually, forestry will ask for that too. But it's an appropriate question, but you can't always get forestry to say, not, we'll do that, because you may say, I really want to put an elm, and they say, oh, no, we're not doing elms or ash or whatever it is. So the forestry department may override that. I don't see a lot of it, Keith. I do see, and you will notice in the example that I put up on construction practices, that they protect the existing trees, is a part of that construction practice requirement.
I guess, just to put that in some context, you know, we had a developer come that wants to develop a property that's already, you know, they're trying to update it. And they're gonna change the setbacks. And my question to them was, when they do that setback change, you know, you're taking out probably, you know, a dozen like shade trees for this neighborhood when you do that. And just wondering if there was a way that we could do this kind of agreement with them, that they, you know, would try to preserve as many of those trees instead of just paying to like the new tree fund, which, you know, we'll put in a sapling that, you know, takes another 60 years to kind of get back to where it was.
Absolutely fair to ask that there be a certain minimum caliper of all trees planted with respect to the project. Those are all fair game. Again, there's as long as you're willing to make a reasonable ask. I mean, the tiny little trees, some of which don't survive and are not guaranteed, can be problematic. And so asking a big developer when they're putting in a project in your neighborhood that you want a larger caliper tree is absolutely fair game to ask.
Thanks.
And then I'm gonna comment regarding Megan's question about getting a conclusion and a short explanation sheet that's been vetted. Again, these two retired attorneys are not giving out legal advice tonight, and we will not be providing any kind of document that will be any kind of legal advice. And also, as far as something short goes, since there is such a myriad, we've covered so many different topics, from Park Hill to big condos to single families getting upzoned. There's really not a short 1-page explanation that we can provide regarding Ginny's, but we've got a couple 100 pages instead. So hopefully that'll be good enough.
Well, and in Chun, I think that came from someone with Chun. Chun has resources, so I think they could probably find somebody within the Chun group that can help them if that's what they need.
And then there was one more question, or two more. Where do you stand on the potential closure of 7th Avenue between Grant and Sherman?
I don't know who that's asked to, but it's really not the subject of tonight's meeting.
Okay. And then Keith, you have, go ahead.
I do think it's part of the whole, pardon me for interrupting. I understand the concern, and I think it's part of the whole city's response to, okay, during COVID, we let people encroach onto the public right of way in ways we never had before. And in my opinion, not familiar with the 7th Avenue thing, it's something that I'm concerned about, because it limits the access of some people with certain kinds of mobility issues, and how they can get around and get off sidewalks and so on and so forth if everything is blocked by eating establishments or drinking establishments. But I
do know about that now. I do know, because I've been to several of those meetings. The city has already finalized its rules for expansion of eating establishments, which of course can also, they haven't done it yet because I've asked these questions on whether the liquor license automatically applies to that, and nobody addressed that during COVID, but they're going to in the rules. They've finished the ones for private property and public property above the curb. And now they're dealing with what is appropriate and what can be done below the curb, so that they would take out certain parking and put those, but those you can find, and we will get that link to you if you want to look at where those rules are right now. I know several people on this call were on the last city's outline about what those proposals were.
Keith, you want to ask your other question about transfer of ownership of a license?
Yeah, I'm just trying to understand this better because I think what I read earlier, which maybe was an email or some documentation from the person at the city that you were talking about, Lou, that emailed earlier today, is that the city is under no obligation, and neither is the licensee under any obligation to notify the neighborhood of a transfer of license. Is that correct or is that incorrect?
Well, we get notified because you get notified of the, let me take that back. There are certain things where you will get notified of change of ownership, but they do not have to notify you. And so now asking for and requiring that there be prior notification and that the transferee enter into an assumption agreement or a new good neighbor agreement with respect to that liquor license or cabaret license is not going to be put on the face of the license, basically.
Okay, but we do get notifications as RNO delegates or presidents, or the RNO is notified of a transfer. Though
That
from
is my
excise,
understanding. Yeah,
but that's not necessarily a notification from the owner
that's
of
right.
the license.
That's right.
Okay, okay. I think
Gertie,
that
you want to chime in?
Yes, I do, because the city will send us notification of the transfer of the license. We'll send whomever the RNOs have listed as their contacts with the city. Those contacts will get notice of a transfer. However, it's my understanding from recent communication with excise and license that the terms that are on the license will automatically transfer. But the enforceability of the GNA does not transfer. It's only the terms that are on the license. That's why, in my opinion, those are, from a small RNO perspective, without deep resources and a lot of legal legals that are willing to help with this. That's the most important thing, is getting it on the license. We had a lawyer approach me because I had negotiated another GNA with him on behalf of another RNO. Contact me and say, I have a client who is purchasing the license for another establishment in your neighborhood, and we want to negotiate a new GNA. What I didn't realize was what they really wanted was they wanted changes in the terms that were on the license. And that was that was the one thing that the RNO had in terms of consideration. Were we willing to change some of the terms on the license to give them more latitude in the dance floor than the previous GNA had allowed? And they would then enter into a new GNA. Does that make sense to people? I hope so.
Yes. What RNO are you referencing, Gertie?
Well, I'm schizophrenic. I live in 3 RNO districts. There's West Wash Park, there's the Lincoln Broadway Community RNO, and there's Baker. This one was on behalf of Baker, but most of the GNAs I've negotiated have been on behalf of West Wash Park.
Awesome. I'm going to ask a question that I have regarding the only GNA I have worked on. We had a developer going to build some townhouses, say that he was going to abide by the host regulation of making 2 of those units affordable. And it was recorded in our GNA. And now come to planning, though he has done the buyout, which I thought you weren't allowed to do anymore, but I guess you are still allowed to do. So as far as enforcement for us, if we wanted to enforce that, is that when we'd have to go and get a lawyer? We have nothing in there saying they'd pay for legal fees. So would that then be on us if we wanted, if it was, I guess, worth it for us to go
Well,
after?
did you file that with the
It's recorded. Yeah.
court against property, but was it also with the city?
You know,
I'm just wondering.
I
You know,
have to
so
look into that.
once you start getting into specific facts, you know, I don't want to, again,
Sure.
cross that line, but
Yeah.
you know, the things that an RNO can do would be to say, get that agreement to the host staff and say, this
Okay.
is what we really want for this property.
Okay.
And you have to look at the language and see whether the language in your agreement was tight enough to actually say you have to build it on site. So there's so many factors that you have to look at to see how it might be interpreted. And then if there's really a violation, you know, you should send a letter to the developer and say, okay, what's up with this? And then you have to think about, well, what's your remedy, right? Because you enforce it because of what were you trying to accomplish?
More
And-
affordable units, right?
Yeah.
Affordability. So 2 teachers maybe could live in the neighborhood.
Right. No, I get it. But those are the things you'd have to understand and really look at.
Okay.
And, you know, I think that it's fair to bring that up if you haven't with your board or whatever. Was that with Harkness Heights?
It was with Brunn, with Berkeley Regis.
Yeah. Okay. So, you know, you've got some resources there that probably take a look at.
Yeah.
And then approach the folks at the city who deal with affordable housing. And you might
Yeah.
also look and see whether that lens was under the new Cap A affordable housing, you know, so has it changed? Are those requirements still there? So there's a lot to unpack there, Amber, that I think you'd actually need somebody to look at.
Okay, great. Thank you. Appreciate it, Lou. Awesome. Any other questions? Looks like we got all the questions answered unless I don't see any more hands. And then if not, I'll turn it back to you, Keith.
Yeah, I do just want to give, I know Lamone's on here now, so I wanted to give her a quick opportunity if she wanted to, if Lamone, you want to say anything about any DEI stuff coming up or where we're at. If not, that's okay too.
Hi, I was just trying to get back online. Sorry about that.
Sure, no problem.
Yeah, we are working on a DEI event, connecting it to RNO 101 so that it will be similar to a boot camp, maybe a day-long event where you're learning and planning how you're going to implement DEI. So we got to figure all those details out, but basically, we want it to be something that is just inherently part of the process rather than a policy or an obligation that you have to remember to do. And the other thing about DEI, it is not an affirmative action program. It's about being mindful of who you're interacting with, who you want to bring into your organization, etc. So more about those details later.
Great, thanks, Lamone. And I also wanted to quickly say if Steve Smith or Joanna, you want to speak for a minute to introduce Steve? I think Steve might be here.
Hi, I just wanted to give Steve an opportunity. As I said to everybody, he is my co-chair for the Education Committee. So Steve, take it away.
You're muted, Steve. Can't hear you.
Can everybody hear me now? I'm so sorry.
No, you're fine, Steve. We can hear you now.
Yeah, three kids at home. It can get a little bit tough at times.
Yeah.
I was listening for my name, but obviously I didn't hear it quite fast enough. Just a quick update on the Education Committee. Like for those of you who don't know, my apologies. I'm just walking outside, as you can hear. Like I'm going to be doing the co-chair with Joanne. And basically the only update is I really appreciate everybody. Joanne was a little bit late in getting some proposals ready for July 31st. So I see that we have a procedure that's been used previously. So I'm going to be sending that out. But if you happen to know of any educational organizations that are worthy of something like this, I think we've got a protocol that we've used in the past that I'd like to institute again. And basically, instead of making recommendations for July 31st, we'll make them for August 31st or even the end of September, and then just try to get these awards out as soon as we can. But does anybody else have any follow-up questions or?
Just want to say a big welcome to you, Steve, and we're excited that you're on board, and you know, excited for stuff that the Education Committee can do this year and next year as well. So just big welcome.
Yeah, then I think, like I said, I know there's a little bit of overlap from the meeting we had from a couple days ago, and I'm sure this will be repetitive for a lot of people that are there. But like I'm a teacher at Lake Middle School, and then my background, I used to work for state legislators and governors. So like the big reason I got involved with this is that as an old white man, I'm sure as hell not going to be the one to call the shots in DPS. Like I'm not one of those white guys that we all know who I'm talking about. But like what I do want to do is amplify community voice. So the only like policy that I will ever advocate through Denver Inc. is to make sure that community voice is amplified as much as it can be. And I think in the last two attempts to solicit community voice in a district full of 90,000 students, I think they received 360 responses and then 165 responses. And unfortunately, as many of you may know, community outreach is rarely done authentically, and it's often just like another box to check. And I just think like our community deserves better. And when I saw Denver Inc., I was like, this is the perfect infrastructure in which we can amplify community voice. But that's the only thing I will ever be advocating for. It'll never be for any particular position. So I just, for those of you that just had to hear my spiel again, my apologies. For those of you that just met me, I just wanted to let you know where I'm coming from.
Thank you.
Yeah, great. Thanks so much, Steve. All right. Well, yeah, just everybody, just remember if you've gotten an invitation for the upcoming event in September, we would love to see you there. We're hoping to get a good turnout and make sure that we all get a chance to see each other again. This has been a couple years coming that we haven't been able to do this because of COVID. So we're definitely very excited to get it back together. Jane.
You just had in your notes that the 13th was what, Tuesday? It's the
Tuesday.
13th is a Wednesday, so it's
Right,
Wednesday,
right.
September 13th. The reception is at 5:30, and the program will start at 6:30.
Great. Perfect. Perfect. Thanks so much, Jane. Anyone else? Michael.
I've just got one comment, particularly to Steve. Denver Decides has been a partnership for 20-some years with Channel 8 in Denver and the League of Women Voters. And we are going to have, and we need INC's help in publicizing it, but particularly the Education Committee, because we will be having a forum, or I should say, 3 different forums in October for the school board elections. There's some very important school board elections. And Steve, hopefully we can get your committee and your point of view involved in that. And Jane Potts and I and Greg Sorensen are the INC representatives.
Perfect. No, I really look forward to meeting with you. And if you check in the chat, I just dropped my email in there, and like I have that with me all the time. So yeah, drop me a line, and I'd be happy to help you in a lot of those endeavors.
Terrific.
Yeah, please do email me. Do you see it in the chat there?
But well, I can get it from Keith, I'm sure.
Yeah, I can get it to you, Michael.
Yeah, if you could do an introduction, Keith, that would be fantastic.
Perfect.
Hey, thank you guys.
Well,
you.
again, a big thank you to Lou and Gertie for the masterclass tonight. We really appreciate it. And to Amber for also helping to organize this and put this together. So thank you very much. If there isn't anything else, we will conclude for tonight, and we'll hopefully see all of you in just a month at our awards ceremony. And then we will hopefully be back in person or doing a hybrid meeting in October. So if not, we'll see you then.
Thank you, Keith.
Enjoy the rest of summer, everybody.
Yeah. Take care, everyone.
Ciao.
Take care.